We regret that due to deliberate and concerted efforts to derail this case through witness interference, the judges have been prevented from determining the guilt or innocence of the accused on the full merits of the case.
It's fair to say that that the Kenyan cases, in my view, collapsed from the word go. They were never meant to be before the ICC ab initio, for the reasons that I think were articulated very well by one of the judges during confirmation, the late Justice Hans Cole, was very clear that what took place in Kenya in 2007, 2008, that 1 week of madness, if you like, was unfortunate. The deaths and the displacements was unfortunate. But that, based on the statutory standards of the Rome Statute, he could not find any reason, for those matters to go before the ICC, because they could not meet the threshold, of crimes against humanity, and they could not meet the gravity in terms of the widespreadness, of the crimes. You can see a case that was built on quicksand from the word go, and every effort has been made to sustain it, to keep it, to hold it together, lest it collapses. When the prosecutor began to appreciate the fact that that the office had a very weak case, they began to resort into what we call really legal gymnastics, if you like.
We obtained warrants of arrest for Mr. Walter Osapiri Barasa, Mr. Paul Gicheru, and Mr. Philip Kikoch-Bet on charges of obstructing the course of justice. Yesterday's decision noted that the accused profited from such interference with the administration of justice. I call on the authorities of the Republic of Kenya to surrender these 3 suspects to the court so their guilt or innocence of the charges against them may be determined in a trial.
Before you make a decision as a prosecutor to charge certain people or to indict certain persons, surely there has to be a bedrock foundation of evidence that links the crimes to these individuals. I mean, these persons clearly, from even a layman's standpoint, they could not be the ones that bore the greatest responsibility. The 2 of them were not competing for political power in 2007. There were other people whom they were supporting. So it naturally follows that the choice of whom to indict was informed by politics. The understanding by Ocampo that, hey, now that we have a president and a deputy, and a prime minister in power, they cannot give, we're not going to try them, but instead we will try their lieutenants. And that again just says a lot about the politicization, even of prosecutorial choices. 8 good witnesses who had said, look, we are no longer part of this case. We don't want to be part of this case. We are not interested, because what we said before was a lie. It was a concoction. It was a product of a fertile imagination. These guys did not want to be part of the process. What did the prosecutor do? She went to court and basically said that the ICC statute empowered the court to compel witnesses. Now, our reading as a state party called Kenya, our reading of the statute that we signed into, Article 64 itself, is very clear on the voluntariness, of participating in proceedings before the ICC. Now, unfortunately, we appeared before the court. We made our submissions opposing very strongly the attempt to amend, as it were, through judicial process, to amend the statute. Very plain, clear, unambiguous provisions of the statute on the voluntariness, of witness participation. But the court, both at the trial level and at the appellate level, disagreed with us and led to the, resulted in Kenya being actually asked to compel witnesses. And Kenya, as a good state party, contrary to what you have heard, of what has been written about, as a good state party, despite its own misgivings, about this, went ahead and provided the necessary facility to ensure that 5 of the witnesses were summoned and that via video link they were able to give their testimony. It's extreme inconvenience that the country and the individuals have been subjected to, and the families and the communities.